at the front lines of law, leadership, and public service. From the courtroom to the classroom, Attorney Karen Jimeno brings sharp legal insight, academic excellence, and a voice that has guided national conversations. Attorney Mike Toledo, a seasoned public affairs strategist and legal mind with years in media, corporate leadership, and government reform. Together, they bring law to life with experience, integrity, and the courage to ask hard questions. Two minds shaped by the law. Two voices trusted in and out of the courtroom. This is Abogado.
Good evening and welcome to Abogado, the program where we bring clarity to the law and tackle questions that shape our families, our rights, and our nation. I'm Attorney Mike Toledo.
And I'm Attorney Karen Jimeno. Tonight, we dive into an issue that tests how tradition meets modern realities and how the law keeps pace with the changing lives of Filipinos. Let's take a closer look at our proposition.
Divorce may be legal in other countries, but for Filipino citizens, the law draws a hard line. If a Filipino gets divorced abroad while still a Philippine citizen, that divorce is not automatically recognized. Under current Philippine law, a foreign divorce may be recognized if it was obtained by the Filipino foreign spouse under the national law, and the Filipino spouse secures judicial recognition in a Philippine court. Now, with an ongoing petition before the Supreme Court, this issue has returned to the spotlight, challenging long-held interpretations and reigniting the national debate. Is this about protecting the institution of marriage? Or is it time to uphold the rights of Filipinos living within a global reality? Should a foreign divorce obtained while still a Filipino be recognized in the Philippines?
Arguing for the recognition of such foreign divorces is Attorney Danielito DJ Jimenez, a trial lawyer for 27 years and a longtime professor at the University of Santo Tomas. He holds several degrees, a Juris Doctor, Master of Laws, and Doctor of Civil Law, and is the author of a book on male domestic violence. Widely known as the Pinoy street lawyer, he has offered free legal advice to Filipinos since 2011.
Now, against foreign divorce recognition is Dean Amado Valdez, the former Dean of the University of the East College of Law. Beyond the academe, he has held key government posts as Undersecretary at the Office of the President in 2002, Chairman of the Social Security System or the SSS, Government Corporate Counsel at the Department of Justice, and also the Executive Director of the Visiting Forces Agreement Commission.
Before we begin, here's how our discussion will proceed.
We begin with the opening statements. First, the speaker supporting the proposition presents their position in a focused 2-minute statement. Then, the speaker challenging the proposition offers their perspective, also within 2 minutes. The conversation then unfolds through 2 key subtopics. For each subtopic, the guest supporting the proposition presents their insights for 2 minutes, followed by a 2-minute perspective from the guest challenging the proposition. After both perspectives have been presented, we move into the open exchange. A 6-minute free-flowing discussion where both guests ask questions, share points, and respond to each other directly. Once both subtopics have been explored, we proceed to closing reflections where each guest is given 2 minutes to summarize their key messages. And finally, the hosts step in with their own questions. In this 6-minute segment, the guests respond, clarify, and deepen the discussion, ensuring no critical point is left unexplored.
And now we begin with opening statements. The question, should a foreign divorce obtained while still a Filipino be recognized in the Philippines? Attorney DJ, our street lawyer, you have 2 minutes.
Divorce isn't something new in the Philippines. In fact, prior to the 1987 Constitution, even before, we did have divorce in the Philippines. And no less than our family code also recognizes divorce when it comes to mixed marriages. And aside from this, we've seen in numerous cases, no, in the Orbesido, in the Manalo cases, and recently in the Nang case, the Supreme Court somehow has been very liberal in recognizing foreign divorce. And it is for this reason that I appeal that foreign divorce obtained abroad, subject to certain restrictions and to certain applications, should be applicable and should be treated in the Philippines.
Okay. Very concise. Thank you, Attorney DJ. Dean Valdez, your opening statement. You have 2 minutes.
If I may add.
Yes. Okay, so you have 2 minutes pa naman. Go ahead.
Likewise, citing the Equal Protection Clause. And I think it would really be unfair if a Filipino who has been divorced abroad will have very limited rights in asserting the divorce in the Philippines.
So equal protection with respect to their spouse.
Yes.
Okay. Dean Valdez, your opening statement.
Yeah. There's really not much difference between my position and that of DJ. Actually, recognition of foreign judgment is provided in our private international law. I just want to point out that there are instances where a divorce has been obtained by Filipino citizens, for example, abroad, and that is our topic actually. But if the ground for that divorce is actually psychological incapacity, which is provided in our civil code, I think it is a matter of committee on the part of our courts to recognize that kind of divorce. Even if legally we do not recognize divorce, but there's something in the civil code where psychological incapacity, which is actually a euphemism for divorce, has been allowed. So if a couple obtains divorce on the basis of psychological incapacity, then the court, the parties could ask that the same should be, that foreign judgment should be recognized. I think I was assigned to take the cudgels for the non-recognition of divorce.
Yeah, you have the negative position.
That actually put me already in a bind, because I know for a fact that when you say recognition of foreign judgment,
it's
recognition
that's already
assumed that such kind of judgment can be recognized.
Yeah, okay. So let's go into that, Dean Valdez and Attorney DJ, more in depth, because even if we recognize foreign judgments, I guess a question of recognizing foreign divorces obtained abroad would be on the part of Filipinos that initiated abroad. So that's where we are having our debate here, kasi yun yung parang hindi pa masyadong tanggap sa Philippine law. So let's start with the constitutional validity and public policy. How does the recognition or non-recognition of a foreign divorce by a Filipino citizen measure up against constitutional principles on marriage and family? Attorney DJ, you have 2 minutes to share your perspective.
If we will be strictly applying the concept of divorce in our Constitution, the Constitution per se does not prohibit divorce, but what it provides is that it considers the family as the foundation of our nation. And with the family, the foundation of every family is, of course, the marriage. And the marriage is an inviolable institution that the state must protect. But it doesn't say that divorce is not allowed. And based on some of my readings, even in the deliberation of the 1987 Constitution, it was never an option to outrightly ban divorce. So it is a question of what really is this policy ba? And when you do not, when you recognize divorce to sever a marriage, are you really destroying the marriage? What if it's a bad marriage? Are you not also protecting the family when you allow a marriage to be resolved? In fact, you're not encouraging people to sin because you're allowing the divorce. So these are very very interesting concept that needs further discussion. But there's no hard and fast rule saying that divorce is illegal or should not be allowed in the Philippines. And ironically, it is only the Philippines and the Vatican who does not have any law on divorce, save the Muslim in the Philippines. No? So that should, that should give us time to really reflect if the changing times warrant the revisiting of these policies.
Before I go to partner, before I go to my good friend, Justice Valdez, just to add to what you said, you're saying that the Constitution does not really strictly disallow it. And in fact, partner, para malaman na natin mga kababayan, talagang noon na allowed you divorce eh. If you follow the evolution of the divorce law, it was allowed during a certain period, even during the Spanish time, and then it was the Japanese time as well, and then in the American time. And
interestingly, because under the Spanish regime, we were a Catholic state, right? Like
may mga moves. If you follow the history of the divorce law, you will see that there were really moves to allow. There were liberal times to get a divorce. Then there were stricter times. Then it came to a point when they were crafting the civil code at the time. They decided to make it stricter. Kaya nga it is funny. A lot of people would say na we're more popish than the Pope, di ba? Yan mga sinasabi nila.
More popish than the Pope. Ngayon ka lang narinig yun.
Kasi unang-una. Dati, there were 3 countries that did not allow divorce while the whole world allowed it. That was Malta, the Philippines, and the Vatican. Then Malta, sometime in the 90s, if I'm not mistaken, already allowed divorce. So that leaves us with just the Vatican and us. I'm not saying it's wrong. It could be a badge of honor. But at the end of the day, this is something that's really being discussed right now.
Yeah.
So with what Attorney DJ just said, what is your opinion, Justice Valdez?
Well, segue to what you have been saying, where there were changes in our policy on divorce. I had the suspicion, and this is the result of some talks with old lawyers, that the legislation of divorce had been also motivated by some of those who wanted to take advantage of the law. They wanted to have divorce, and then they have to legislate it to have divorce. And then when the institutions, the religious institutions like the Catholic institution asserted itself, then it shifted back to having divorce. I don't know if time will come that when necessity would dictate on some personalities that a divorce is necessary, then they finally legislate divorce. But somehow the more objective point is, to me, divorce can be provided in our laws, provided there are certain strict parameters, and the proceeding should be strict. And sometimes the expensiveness of the proceedings could also be a deterrence in people trying to obtain divorce. That it's better to love each other, which is not very expensive, than
it depends who you're married to.
Than going to court and spend so much.
But
to me, love is not expensive. So
it could be expensive.
I love it. So, pero then practical argument, si Dean Valdez. Well, kanina, my partner, Attorney Mike, already kind of started this open exchange for questions and discussion. So, but now we'll formally start this open exchange. We have 6 minutes for this, but if there are any clarificatory points, now is the time to raise this. And I have a few questions I've reserved for myself, but I'll let you start off, Attorney DJ or Dean Valdez.
There are no ones.
Go ahead, sir.
DJ. Okay. There are certain nuances when you speak of citizenship vis-a-vis capacity to apply for divorce. There are situations where a person has dual citizenship. And if that person applies for divorce and he is mixed Japanese and Filipino as a dual citizen, what personal law would apply?
Interesting question, yeah.
Because we are governed by the nationality principle.
Article 15.
That's why Filipinos cannot obtain divorce if they are Filipino citizens, because the national law applies to us. But suppose you're a dual citizen. You could be Japanese, you can be Filipino. So there are criteria that can be invoked. If you want to have the divorce that you have obtained valid, you can invoke Japanese citizenship. And what will you argue to justify the fact that you are a Japanese citizen? There is this standard in private international law where the law that has the closest significance to you would be the citizenship that will be governing.
But
Do we apply that, Attorney
Well,
DJ?
I think the more interesting question is, there's no doubt if it's a mixed marriage, the Supreme Court has spoken. Whether it's the alien spouse or the Filipino spouse initiating the divorce, that will be recognized.
But the question is,
what
prevailing
if both?
doctrine now? Because
in the Orbicido and the Manalo case,
because before it
that
was really
prevailing.
only the foreign spouse that can initiate the divorce para ma-recognize ito.
Because
But now, pwede na.
Because at the time, if you interpret Article 26, very clear, the alien spouse. But yun nga yung sinabi ko kanina, the Supreme Court has been very liberal lately in interpreting this provision. And there's, I think, a pending case before the Supreme Court. But this does not initially involve a mixed marriage. Pareho silang Pilipino. Nag-divorce na agad. And then later on, saka pa lang naging alien spouse yung isa.
Interesting. So that's the pending case in the Supreme Court right now. Kung nagpalit ka na ng citizenship later on, will that make your divorce valid? If nauna ka mag-file before ka maging foreigner?
Pwede ka mo pa ba siyang i-invoke yung Article 26 given na at the time that the divorce was secured, parehas kayong Pilipino. And under Article 15, family laws, laws relating to family rights, duties, status and condition, even successional right, apply to Filipinos even though living abroad.
So hindi pa naman to violating the sub judice
rules? We are discussing general principles of
past decisions na yan. Past decisions yan.
I'm glad that you mentioned Article 15 kasi yung Article 15 ng Civil Code actually related 15, 16, and 17 of the Civil Code are all related, di ba?
Yes.
And the 15 is basically yung nationality principle. Wherever you go, the Civil Code applies if you're a Filipino, di ba?
Yeah.
And the same way that the Lex Lostae celebraciones, di ba?
Yes.
Marriage, wherever it's celebrated, if valid there, is also valid here. Now, if divorce is validly acquired in that country where the divorce was obtained, then it is also valid.
There.
Well,
there, di ba?
Only if you're not Filipino, right? Because as Dean Valdez already mentioned, one fundamental principle we have is your...
No, but in one case, partner, the Filipino that even initiated the proceedings, the divorce proceedings in the foreign country, it was a Filipino. But it was granted.
Yeah, it was recognized.
It was recognized. So since it was granted, so it went beyond the latter case, the Orcebido case, if I'm not mistaken, even went beyond what the Manalo case provided for. So ang nangyari, sabi nila, no, pwede, maski ikaw nag-initiate, as long as the proceeding is valid where it was initiated, then in that case, pwede yun. And in fact, sinabi ng korte doon, it did not even be a judicial declaration. It could even be by mutual agreement. So talagang liberal.
In the recent case naman, administrative divorce,
administrative lang.
recognize din ng Supreme Court.
And both Filipinos as well. Is that
Japanese
correct?
visa.
Mixed marriage.
Mixed marriage.
So
Kasi
kaya
pag mixed
magkakasalo rito
marriage-
kung
Yeah.
both Filipino.
Yes.
I agree. Kasi
Correct.
I find this to be a very relevant topic because I've had this question posed to me so many times. I've had friends who were married abroad. And just because they were married abroad, both Filipinos, they think they can get divorced. And they would always tell me, no, but we were married in the US or we were married in
Yes.
Australia. And I'm
Yes.
like, hindi relevant yan. Because if you're both Filipino, then you cannot get divorced.
Yes.
So this ruling by the Supreme Court would really make a big difference
It
for
would
Filipinos.
make a big difference because later on, naging foreigner na yung isa. So,
Oo.
sinasabi ng petitioner, mixed marriage pa rin to, pero sinasabi ng Office of the Solicitor General, hindi, at the time you acquired the divorce, ano kayo?
Kaya nga ito
Yeah.
Supreme Court na to,
Filipino
hopefully,
kayo.
partner, the purpose of this petition, hopefully, it will clarify once and for all. Kasi correct me if I'm wrong, gentlemen. Di ba medyo iffy pa rin eh. There are still some uncertainties. Hindi pa rin masyadong clear. Di ba?
I think maglalabas ang Supreme Court siguro dyan ng guidelines, no? Para mas maintindihan ng bar and the bench.
We're into the realm of creative law. At the outset, I was saying that if two Filipino citizens pa rin sila, and then they applied for divorce in the States based on psychological incapacity.
Dapat i-recognize.
And they presented Philippine law as the basis of their psychological incapacity. And the judge of California, for example, granted it on the basis of Philippine law.
Ang
Meron
problema
bang
lang-
jurisdiction yun?
my point is, if the parties comes here and ask for a recognition of that divorce, will our court grant the petition for recognition?
Interesting. Kasi this would
Because,
be a
yeah,
question of
there's-
also private international law. Can you...
It does not violate
Yeah.
our law because
Conflict of laws.
we have psychological incapacity under our civil code.
Very interesting and very timely, partner, na we're going to the next subtopic kasi
Yeah.
naubos na yung time
I
natin
just
for
point
that
that
open
out because
discussion.
I don't want to subjudice tayo.
Yes,
Okay,
yes.
something
Ang
new.
nakakatuwa ho rito, the concept of psychological incapacity is very unique and only applies in the Philippines. Wala pong psychological
The,
incapacity.
Sa
the,
ibang
term,
bansa.
the term is not used there.
Yeah.
But
The grounds,
in my
maybe.
example,
The grounds.
it's always possible because there's this principle of committee that if you prove that this is the law that applies to you, and you are in the state, you are there because of circumstances that you are there, you file for petition based on psychological incapacity. And magaling ang lawyer mo, you were able to get divorce on the basis of psychological incapacity. Balik mo dito, can you now claim that you are divorced from each other because it is a foreign judgment.
That is legal.
That
based
has
on the-
jurisdiction.
Yes.
Yeah.
But the grounds invoked was the law obtaining in the Philippines.
Kaya yan na yung mga
Oo.
partner, yan yung mga
Intricacies,
conflict of
oo.
laws, intricacies. Kaya nga yan ang isa sa mga talagang siguro bibigyan tugon ng ating Korte Suprema dahil nga on the legal and practical considerations. Well, we're trying to balance the legal side, binabalance din yung reality on the ground and yung potential procedural conflicts. So
Yeah.
now as my partner mentioned, no, we go down to the next topic, which is actually to turn into the rights, the equal protection, and the modern realities in a globalized world. Does the current rule, gentlemen, as on foreign divorce, treat Filipinos fairly, or does it create an unequal treatment compared to those that were married to foreign nationals? We sort of touched on this already, and my partner also touched on this already, but we would like you to expound it some more.
We'll start with Attorney DJ.
Siguro, yun nga, is there really a need to make any distinction when the acquisition of divorce was obtained, so long as eventually the other party becomes a foreign national? If you will be strict about it, then of course this would, if the Filipino spouse who is left married, this would result into what we call nga as limping marriages. Valid sa ibang lugar, invalid dito. Isn't that violative of the equal protection clause? So I think dapat po ito, this should really be studied very well, and kailangan po i-take into account din, no, yung equal protection clause nga, because ultimately if we will have any practical considerations, di ang gagawin lang, hindi ka inalaw kasi na-acquire mo yung divorce nung ikaw ay Filipino pa kayo pareho, di mag-file na lang yung isa ng divorce uli. So parang ganun din eh. Parang kung titignan mo, it doesn't, it's very technical at the expense of the other party who is left to be married as far as the status is concerned. Di siya makapag-asawa. Then isn't that violation of the Equal Protection Clause?
Okay. Thank you, Attorney DJ. Dean Valdez, your perspective.
Well, I think we have to look into the consequences. If the application of the law would result into scandalous or anomalous or adultery situation, I think the law also has to come in to prevent that situation. If by upholding that foreign judgment, it would result and a clean slate without the stigma of scandal, the stigma of having to be forced into an existence which the public will brand as adulterous. Yet, for all intents and purposes, the relationship has already been severed. I think it has to be looked with kindness. That's why there should be some kind of broadness in order to achieve what you call the equality, equity, justice. As I said, one possible legal argument that you can maintain is the basis of the divorce which we obtained, which was granted despite the fact that we are Filipino citizens, is a ground that is provided in our own civil law. So even if the divorce has been granted in another jurisdiction, when they come here and ask for a recognition of that foreign judgment, then it has to be recognized.
So basically, Dean Valdez, you're saying that okay lang for Filipinos to obtain a divorce abroad as long as they use the same ground that's recognized in the Philippines, which would be psychological incapacity.
Yes, I think so, because as far as our courts are concerned, which is its dockets are full, I think we have to welcome that one case left disposed of, rather than it will be a case that is one of those that will be burdened to our courts.
Well, here's a technical question. Pag ganun ba, will the Office of the Solicitor General have the personality to appeal
always
that
naman,
decision?
always. Because,
kahit nagaling sa abroad.
Of course, because this involves marriage.
Pero pagka ba foreign divorce, pag pinapa-recognize mo dito, hindi mo pwede mag-appeal yung OSG, right?
Because essentially you are nullifying the marriage.
Yes.
So because you cannot nullify a marriage unless there's a court declaration. So OSG as the representative of the people in the state.
No, but let's say taking out of the Valdez's example. So kunwari foreign yung husband and yun yung kumuha, nag-initiate ng divorce and nakakuha ng final judgment of divorce in the US at pinapa-recognize na lang dito. Hindi na pwedeng i-appeal yun ng OSG, right?
Well, in theory, since it's a family case and OSG is always there, if there is ground to appeal, they would always. But my point here, I think, is that in the context of the Equal Protection Clause, I think what should be relevant is in recognizing a foreign divorce, regardless of what the situation is, would that be really offensive to public morals? Because if it's not, and it is only prevented because of some limitations or technical interpretation in the law, I mean, courts would always be liberal, and that is what had happened in the cases that interpreted Article 26.
I'm glad that my partner, Attorney Karen, raised the OSG. And I'm looking at it at a practical standpoint. Kasi, alam mo, talagang ganun nangyayari, partner. Pag, because the OSG is supposed to be the lawyer for the state, and the state under the Constitution, the Civil Code says marriage is not a mere contract, but an inviolable social institution. They have to appeal automatic. Pero I am now sharing with everyone here and the public, yan po ang nagiging isang problema sa OSG. Marami pong kaso na talagang haharapin ng OSG, especially right-of-way issues. Kaya connected na rin to sa infra, no? Right-of-way issues. Nagkakakulang ng abogado. Bakit? Dahil busy sila sa automatic appeal ng mga annulment cases. Kaya I'm really glad na meron tayong bagong Solgen na nakita itong problemang ito dating Dean ng UP College of Law, no? Si Dean Beberabe.
Okay,
Just to digress a bit, because I'm glad you raised that part. Crucial eh. So yung practical side na automatic lang nag-appeal, pwede pang wag na automatic. Tama.
At isipin mo rin yung mga mag-asawang gusto na talaga magpa-annul. Tapos mapapagastos pa sila kasi nag-appeal pa yung OSG. And yet, among themselves, they really want to get annulled already.
Kaya kailangan nga i-revisit ano ba talaga ang state policy on protecting the family? Is it really blindly protecting failed marriage or a marriage regardless of the status?
Yes.
Yeah.
So, kaya lang, ang problema dito, of course, andyan ang Congress, most of the solutions sana are legal and legislative. Pero since this is a very sensitive issue,
walang gusto masyadong...
well, may nag-attempt for a divorce, but I think, and this has always been my stand ever since, no? Back in the days pa sa legal help desk pa noon, CNN.
Oo nga, I was the host before, nag-guest siya sa amin.
They should just expand the concept of psychological incapacity or the ground for nullity of marriage without really saying it's divorce. I-expand na lang, make it more affordable for the people, and very interesting, the Supreme Court recently do away with the requirement of a psychological report.
So parang unti-unti, ninuluwagan na ng Supreme Court.
But this is the tricky part. Yung definition kasi ng psychological incapacity, yung juridical antecedent, which is the ground must be existing even prior to the marriage. That makes it difficult. Kailangan mo pa rin. In practice, hindi indispensable ang psychological report. Kailangan mo pa rin. So, what's the solution here? Siguro, mas maganda kung magkaroon ng case siguro sa Supreme Court, yung juridical antecedent, hindi naman nangangahulugan na acquire ng bata pa eh. Pwede rin siguro during the marriage. It's always...
well, kasi on that note, parang we all split hairs na rin naman because you can be psychologically incapacitated with one marriage, and then the Supreme Court has said in past cases that doesn't mean you are automatically psychologically incapacitated in succeeding marriages. So talagang selective.
Revisit na lang yung concept ng psychological incapacity. Total, tayo lang din naman ang may ganyang concept sa Philippines.
Yung constitutional, psychological incapacity, di ba? Binase naman yan sa canon law. Di ba? It was based on the canon law. Article 36 of the Family Code was actually based on the canon law. And talagang, yun na nga, kasi we do not recognize divorce, the practicality of divorce, which, as we know, one of the reasons nga na kini-question to lahat is kasi anti-poor. Di ba? Yun ang mayayaman lang dati, ang pwedeng pumunta sa labas, sa ibang bansa, kumuha ng divorce, pagbalik nila, divorce na sila. Whereas yung mga Pilipino, na walang kaya, and they're forced to live in either a difficult marriage or live in, quote-unquote, in sin. No? So, ang tanong ko sa inyo, ito kaya pwedeng ma-address sana ng Supreme Court din natin, no? Na
Congress na lang para
Congress.
wala ng problema. And then when they approach it, no, very, very subtle para hindi ka makakakuha ng much objection from the churches.
Alam mo yung role ng Supreme Court dyan is more on balancing of interest. We have rules, marami tayong batas And sometimes you interpret the law, but the interest of one sector will be affected. The interest of the woman will be affected. And then, magkakaroon ng maraming repercussions yan in terms of property relations. magkakaroon ng effect yan in terms of our relationship with other states because if we refuse to recognize their judgment, and they will retaliate against us, and then they will not recognize also the decisions of our courts.
And to add to the justice, diba, yung custody of children.
Custody of children.
Diba? Importante rin yun.
So,
Property also,
the Supreme Court, even if we think of many amendments to the law, the Supreme Court will always come in. Paano natin babalansihin lahat yan? And I think this is the burden being in the shoulders of the Supreme Court now in deciding this pending case.
And it's very interesting that the Supreme Court has been, very, very liberal, no? In many cases, no? For the best interest nga of yan, equal protection, etc. So let's hope for what is best for the people, kasi it's the balancing of interest that's the most important.
Yeah. Well, here's a question, since we were talking about constitutionality. If the Supreme Court decides to allow recognition of foreign obtained divorces that were initiated by Filipinos,
both Filipinos
when they were still Filipinos,
and then later on one became
would that amount to legislating?
Supreme Court, although sovereignty resides in the people and all governmental powers emanate from them, but when we agreed to have the 1987 Constitution and we gave the Supreme Court that power to interpret the law, I think that has to be respected. And again, we go back to the previous rulings concerning Article 26. If you read the law very literally, it should be the alien spouse who should obtain the divorce.
Yeah.
Yes.
In subsequent cases, it
They
has been
expanded.
liberal. Rather,
liberalized.
no? So it is not also impossible that the Supreme Court might also go into that direction for the best interest of the people, and maybe taking into account kung ito ba ay truly offensive sa public policy or practical. So it's practicality over question
in the
of,
past, the Supreme Court has exercised judicial activism.
Yes.
If you remember a decision by Chief Justice Puno before, Justice Pasianon, where a government employee has been in a relationship. Meron siyang previous marriage. But that relationship has been sanctioned by the church. I forgot the...
kahit hindi kasal.
Kahit hindi kasal.
Apo.
But the activism of the Supreme Court recognized the freedom of religion to justify that relationship. Kaya that employee was not deprived of her retirement. Babae ito eh.
So I think we can see that the Supreme Court has really been very liberal.
And the Supreme Court, in that very extreme case, made that decision under the principle of judicial activism. So they can do as well in this pending cases.
It was unanimous and banked unanimous.
Yes, it was.
Just like the impeachment case.
Just like
unanimous.
Unanimous. Okay, very interesting discussion. And I have more questions. Bitin pa nga. So, but for now, we'll have to take a short break. When we return, our guests give their closing reflections. This is Abogado.
Welcome back. You're still watching Abogado, and tonight's discussion, partner, di ba? Talagang very robust, very heated in a sense, but at the end of the day, that's really what we want to know, no? What are really the hot topic issues of today? And tonight we focus on whether a foreign divorce obtained by a Filipino should be recognized under Philippine law. And we've heard the perspectives of Attorney Danielito DJ Jimenez, and of course, our Dean Amado Valdez.
Now we turn to our guests for their final reflections. Attorney DJ, we'll begin with you.
Well, not to set aside the nationality law, but on a more practical note and subject to safety nets, I hope that there will be a time when Philippines would look at divorce in a more liberal way. We are happy to see that in past Supreme Court decisions, the court has been very liberal and even allowing Filipino who initiated a divorce to likewise have it recognized in the Philippines. And it is no different if a divorce decree is obtained by both Filipinos, but later one of them becomes a foreigner, that this should also be applied. And let us hope that in resolving these issues, it will always be best for the best interest of the people.
Okay, thank you, Attorney DJ. Dean Valdez, your closing statement.
Well, our laws are designed in order to create social order. So that kind of social order is manifested in strong marriage, strong relationship. I think in the end, the law has to be respected as long as the interests of the society is served. In the interest of the society is to have a cohesion, good relationship, people love each other, build their future together, and marriage is a vehicle for that purpose. So if a marriage has been recognized abroad, or a marriage has been declared null abroad, and the people will be coming into another relationship here, as long as they comply with the requirements of the society, particularly the requirements of the legal order, then that has to be respected.
Okay, very well said. So now we'll close with the final round of questions. Well, I'll go first, and then Attorney
partner.
Mike,
Yes.
your turn. So reserve it for something you really want to ask that. So
Okay.
for me, actually, this is so relevant to me because I'm married to an American. But I've stayed Filipino.
A good-looking American at that.
So for a long time, my, of course, mindset was,
Yes.
siya lang yung pwedeng mag-file for divorce. And now that Attorney DJ, you mentioned that the Supreme Court has decided that if you're in a mixed marriage, as long as isa sa inyo ay foreigner, the Filipino can now obtain or initiate divorce abroad, and it still can get recognized here in the Philippines. So can you just remind us, ano ba yung naging clincher doon? What made the Supreme Court decide that it would be legal to recognize in the Philippines a foreign divorce obtained by a Filipino married to a foreigner? Kasi baka yan yung key to allowing both Filipinos also getting a foreign divorce abroad.
It's always the intent of the law. Very clearly, the Filipino spouse will be placed in a sad situation if she won't be allowed or he won't be allowed. So I think it's more of the equal protection that has been considered here. And to avoid such precarious or awkward situation.
Okay. So pagka pala nag-stay
Yes.
Filipino both, then they really don't have an option, no?
Yes.
Pero medyo
Filipino, wala.
anti-poor, no? Kasi ang
Yes.
hirap for
Yes.
yung kung low income ka, Pinoy, mahirap magpalit ng nationality, Hindi yun
Hindi
simpleng
basta-basta.
bagay. Oo.
Yeah, totoo. Very quickly, Justice Valdez, your view on that, on what
Well, I agree with DJ.
Attorney Karen mentioned.
I think what is good for the goose is good for the
gander.
Oo, simply said. Oo.
Na ako naman, partner, first of all, no, ang tanong ko simple lang, pero unang-una, I want to make a disclaimer na hindi po to ang aking personal opinion. Pero something to be discussed. Di ba?
Natatawa si Dean Valdez. Usually pag nag-disclaimer, lalong guilty no?
Pero di ba, sinasabi ng iba, or naniniwala po ba kayo? Do you agree? Now, all this kerfuffle, all this discussion, all this debate on whether or not to allow divorce, foreign spouse, Filipino, etc., siguro baka magkaroon ng mas madaling paraan. What if, sabi ng iba, what if in in a marriage contract, just like any contract, may termination period. Kunyari,
May
subject to
expiration.
renewal, by expiration. O kunyari, married. You'll be married for 10 years. Then after 10 years, mag-usap kayo. Ano ba?
Subject
Tuloy ba
to
natin to?
negotiation.
Subject to negotiation. And okay, if nagkausap kayo at nagkaintindihan, sige, another 5 years tayo. Partner, another 5 years tayo. O kung hindi, alam mo, medyo malabo yung 10 years natin. So, let's not do that anymore. So, that's my point. I'm just trying to make it a bit light, but it is something that can be discussed. What do you think of that, gentleman, that put an expiry period subject to negotiation, subject to renewal, just like any other contract?
Merong tawag si Sigmund Freud, slip of the tongue.
That may be difficult, taking into account the state policy of protecting marriage. Of course,
the sanctity of marriage.
The sanctity of marriage. And if you will suggest that there's an in effect, it's also automatic expiration, that may not suggest protecting the family.
Eventually kaya, kasi sabi mo nga, naging liberal na no? Baka the extreme liberal. Is there a possibility?
Yeah, I think
Not that I want it.
I think yung liberal approach should be how to look at how marriage are to be protected. There has to be a qualification. If it's a good marriage, dapat lang naman. But if it's a terrible marriage, if it's a terrible relationship, it's not also healthy for the children. To let them stay in a failed marriage may not be consistent with protecting the family, which is the foundation of this nation.
Yung sinabi mo dyan, I think culture has already created that kind of renewal. Di ba meron tayong 25 years anniversary,
Correct.
50 years anniversary, 75 years. In fact, there are those who are celebrating their 75th
Diamond, no?
Diamond anniversary, and congratulations to those people. No?
Exactly.
So, those things that you are saying, you're just trying to legalize what is already part of the culture.
I see.
I think it's no longer
guarantee.
necessary.
That's not a guarantee. I've already attended 2 wedding anniversaries, both 25 years after a year.
Naghiwalay pa din. So you never
Not a
know talaga.
guarantee.
Yeah. But you know, I feel that in our country, there's also a recognition of yung cultural and religious preferences because we do allow divorce under the Sharia law. So there's that room. But when you talk about a Supreme Court that would eventually become more liberal, I think it's not a guarantee as well, partner, because as we've seen in the United States, when you have a conservative president and they start filling the Supreme Court with appointees who are more conservative, then you can have a scenario similar to the U.S. where they were able to overturn a decision, Roe versus Wade.
Yes.
Because
Eventually, no?
suddenly you had a more conservative Supreme Court.
But the difference is that there is no mandatory retirement in the U.S. Supreme Court. So their judicial philosophy, more or less, extends as long as they live. Sa Philippines, after a term or two, bago na naman ang composition, di natin alam kung ano ang magiging judicial philosophy on a
That should be another good topic for debate,
I know.
partner. No?
Kaya nga sabi ni Attorney DJ, kung decided na talaga ang Pilipinas na i-allow yung divorce, then let's not rely on the Supreme Court to, have to engage in judicial activism. Ano na lang, magpasa na lang ng batas na nanaayon.
And then i-temper na lang. Don't use the word divorce para di ba?
Yeah.
Ganun din naman eh.
I think si Senator Tito Soto said that before when I asked him about his stand on divorce. Sabi niya, he's not in favor of divorce, but he said he's in favor of what he calls an administrative process for annulment.
That's an option.
Yeah.
Simpler, cheaper, so less of a hassle for.
But again, you have to take into account the state policy in protecting the sanctity of family marriage.
Yes.
Galing. Very interesting discussion talaga. So,
Well, anything that really struck you, partner, Attorney Karen, from the discussion so far?
well, actually for me, my biggest key takeaway is how hardworking you are because it's your birthday at nandito ka pa rin working and hosting. So, happy birthday to my partner, Attorney Mike
Thank you very
Toledo.
much. Thank you. Coming from you, it's really something extra special. Thank you very much. For those who would want to know
mag-enjoy ka
my
sana.
age,
I know you have a very VVIP dinner tonight. Oo.
thank you. But to those who want to know my age, you can just private message me. And I will just lie.
And again, we thank you, Attorney Danielito DJ Jimenez and Dean Amado Valdez for sharing their insights on this complex issue.
Tonight's topic shows how questions of marriage, citizenship, and rights challenge our laws to respond to both tradition and modern realities.
And that is why Abogado is here to examine these difficult issues, shed light on the arguments, and help our viewers understand what is at stake. This is Abogado. Good night.
Good night.